And Ms. Hiltz, am I pronouncing that last name correctly?
Litos.
Litos. Okay, still not awesome, but I think it'll do. I think we can make our way through. I may have to just ask you to repeat yourself
Yes.
on occasion, but I think I'm okay.
Okay.
All right. So let me just double check to see if Christine Litos is on the line. Christine Litos, does anybody know if she's coming? Anybody heard from Ms. Litos?
Carry mute.
Yeah. Let's see on the
Now let's confirm your current mailing address. Using the keypad, please enter your 5-digit zip code we have on file for your orders.
Informed me that we have a recording system here in the courtroom.
Great, thank you.
And apparently,
We're calling to let you know that you have at least one prescription that can be filled right now. We're calling about your prescription order for the medication.
On pause
starting with the letters
for a second, and we'll get that
to fill
figured
your
out.
prescription now, please hold while we connect you with our interactive automated system. Would you like to opt in to receive text messages regarding order-related information, such as
Okay, sorry. So we're going to work on the technical. Bear with us just one moment. We'll be with you in just a moment. All right, so I think we're in a similar position. We did some troubleshooting. Not exactly sure why the audio is not as loud here in the courtroom as I would like it to be, but I've got the thumbs up from the clerk that it's adequate for purposes of recording of the hearing. So I think we're in a position where we can move forward. So we'll do just another formal start. This is the matter of Melissa Hiltz and Christine Litos. Today, there was a motion to modify a parenting plan, and also a motion within that is a relocation request. And I think that's to the Pennsylvania area. All right, so let me just double check to see who we have in the courtroom. Ms. Hiltz, you're here and you can hear me okay?
Yes, I am, and I can hear you.
Okay, great, thank you. And then looks like there's a person, it says DV advocate, Hiltz case, Velarde. Could you tell me your name, please?
Yes, Kari Velarde.
Great. Ms. Velarde, are you here? Do you know the whereabouts of Ms. Christine Litos?
I do not.
Okay, all right, thank you.
Thank you.
Does anybody on the call have knowledge or whereabouts of the presence of Christine Litos? So I note for the record that on March 23rd, both parties were present and the matter was set over to, I believe, April 3rd. Let me just confirm this with my case file. Let's see, so we were here on the 23rd and that was set over to April 13th. On April 4th, everybody was here for the readiness hearing. And the readiness hearing, that's where the court set a trial date for today, April 10th at 9 a.m. And well, actually, pardon me, Ms. Hiltz was present, Ms. Litos was not present, Mr. Lawrence was present. And so I guess that's where my concern comes, is that there was a hearing on the 23rd of March, and I'll just confirm this again. And Ms. Litos and Ms. Hiltz were both present as well as Mr. Lawrence. And on that date, it was set, it says the court does not rule on the contempt. Court sets the matter over to April 13th at 9 a.m. And then on April 4th, which was previously set via scheduling order, Ms. Hiltz was present and Ms. Litos was not present. And that's where the court set the trial date to April 10th today at 9 a.m. So that I have some concern that Ms. Litos may think that the case was set to April 13th because of the action taken that took place on March 23rd. And maybe Ms. Hiltz, you can shed some light or perspective from your end, please.
I hope to, because I really didn't want this to be a problem. We really need to get this done. We've been trying to do this for 4 months, or at least I have. So in order to make sure that she was fully aware of the trial dates, I have sent her a text message, an email message, and a Facebook Messenger message in the last week, reminding her and letting her know that the trial was set today at this time. She hasn't responded to any of those messages.
Did they bounce back at all, or did they show that they were So no bounce backs from those.
No bounce backs on the email. No way for me to tell if she's reading the text messages, and she has not read the Facebook Messenger messages.
Okay.
Those do remain unread. However, I replied to an email within moments after she sent me one. So she should have received it. She had been actively using that email address. And I hit reply, don't forget about April 10th, or was it trial next week? Or I don't have it immediately in front of me, but I've made a really strong effort to make sure she's here. Additionally, when we were talking about the contempt at court, and the date for setting it over to the 13th, Mr. Lawrence brought up to the court that trial was set for that week. Christine was present during that conversation, so she was well aware, because we talked about it in open court, that the contempt was being held over for the same week that trial was being held over. And if for some reason there was a conflict on the 13th and the trial ended up on that date, that we would need to reschedule the contempt. And Christine was present for that. I don't expect her to respond or to show up. As you can see, she hasn't filed anything in this case with the court since 2021. All pleadings and responses have been from me.
Okay. All right. Thank you. I appreciate that perspective. One thing I just wanted to just double check, Street, Kelso, Washington. There's been, my understanding, that's been the kind of the status quo address for Ms. Litos. And to your knowledge, Ms. Hiltz, has there been a change of address filed with the court?
There has not. That's actually my brother's home. All of his rental property. He rents it out. It's a boarding house. She moved out of there December 31st of 2019. No less than a dozen times have I reminded her she has to file something with the court. You'll notice I did a motion to serve by mail. And I noticed in Odyssey that there was a return of service when they sent the trial notice to her, and then they resent it to the PO box in Tacoma. So she should have gotten notice, and that's where I've been serving her at. And it's also where I served all of her exhibits at. And she did send me a response to discovery on the 3rd or the 4th via email.
Okay, and the emails that you're talking about is it looks like CR1 and the other is CR. Those are the ones you've used in the past, and you've had responses recently. Correct.
Recently, the responses have been from the Chris phone at Gmail. Previously with the court, she was using Chris Litos at Gmail. Although now that I look at it, I'm in my email right now. It looks like I've been getting responses from both email addresses. So,
okay.
Because her response was sent to me from the Chris Litos at Gmail on April 3rd at 9:30 a.m.
Okay. So the order regarding allowing for service was filed on January 20th, and that was the post office box in Tacoma.
It was, yes.
And was there a notice of that it wasn't able to be delivered there? Mail returned unclaimed, I think was the notice.
Yeah, the unclaimed was when you guys sent the notice
Scheduling
to 606. The scheduling notice to 606 Columbia Street. When I serve by mail and I send one regular first class mail and then I send another one certified requiring a signature, she doesn't seem to be willing to sign the paper saying receive the one for signatures. So I do eventually get those back. I've gotten one packet back from December and one packet back from January, but the first class ones that are sent without needing signatures are not getting returned. Those are getting those are staying there. And I can also see that on her pay stubs that she gave to me just recently this last week, it also lists the PO box in Tacoma, the same one that we are sending to the court. So
the post office box in Tacoma.
Yeah, on her
Okay.
pay stubs.
All right. And so that pay stub has the same post office box, same zip code as that you utilized in serving documents to her of the summons and the petition and all that.
That is correct, yes.
Okay. So Just one last check-in with the parties. Sometimes as a case goes on, some people have some difficulty logging in. So I'll just again call out the name Christine Litos. If you're here, please unmute, state your name. While we're waiting for a response there, I'll note that we're in courtroom 2. I believe the front door is locked. We are streaming live via YouTube, so we're comporting with the open court doctrine. There's nobody in the courtroom other than myself and Madam Clerk. So at this point, I'll find that Ms. Litos is not present. And since there has been adequate notice of today's trial, and there is a petition filed, I think I'll grant the petition. So I think that's where we're at.
Right, I was gonna say, and that was actually one of my questions, is if she doesn't show, what is there for me to do or to say? I mean, I don't.
I mean, your petition has stated your request, and the request is to allow you to move to the Pennsylvania area to attend law school. And let's see, and then the parenting plan. Let me just double check. Ms. Hiltz, do you recall you filed a motion for adequate cause back on December 13th. Was that formally ruled upon? Do you recall?
I don't know what that means. Motion for adequate cause, is that the contempt? That's not
Let's see the
contempt, no.
basis of that, or let's double check.
When you go pro se, sometimes you file funny things because you don't always figure it
Sure.
out exactly right.
Yeah, it looks like your motion for adequate cause filed on December 13th states that the basis that you filed a petition to change a parenting plan, and you asked the court to make a finding of adequate cause to allow the case to move forward. The other party was served. Indicated that Ms. Litos had not utilized parenting time for more than 17 months. So there was that motion.
Okay,
And to your knowledge, Ms. Hiltz, Ms. Litos has not filed any document in opposition to your requested relief of the intended relocation, the petition to modify, the motion for adequate cause.
correct. And I double checked Odyssey this morning to make sure nothing showed up Friday.
Right. Right. And I'm not seeing anything that she's filed in opposition. And so let me just double check to make sure we're on that motion for adequate cause.
I don't know if I did an order. I know I have one printed out here, but I don't know if I filed it figuring we'd do it. I don't really know.
Yeah, I'm not necessarily, it's not popping out. I see orders to show cause on a variety of issues since that time. I'm not seeing a specific motion or order related to that adequate cause. So let's go back to that. Then on the December 13th, that's when the petition to modify the parenting plan was filed. There's also a notice of intended relocation with the children. There was a summons filed on that date. There was a motion for adequate cause filed. There's a proposed parenting plan, a supportive declaration, a notice of hearing, affidavit of mailing, all that happened. So it sounds like Ms. Litos has participated in some of the hearings, and some of the hearings she has not. And maybe Ms. Hiltz, you can inform me, was she in opposition to the move or the proposed petition to modify?
I think her statement was that she was okay with me moving as long as I would give her 2 1 week visitations per year of unsupervised visitation. To which that's not going to happen.
Okay.
The current parenting plan allows for 3 hours a month of professionally supervised visits. And she hasn't used them at all. And so there's no way we're going to 2 1 week unsupervised parenting times without some kind of,
Okay, and is that in your proposed parenting plan? You list some limitations, you abandonment, neglect, and also concerns related to chemical dependency or substance use disorder and reunification. Decision making, you have it as limited. Dispute resolution, you have yourself listed as custodian, and then a limited schedule for Ms. Litos. Basically says no contact with the other parent, except for what's listed in paragraph 4. And paragraph 4 says that she's to have supervised parenting time by a professional supervisor, no contact with the children at this point, but she has to complete the following: a chemical dependency assessment treatment, complete court-ordered, court-approved parenting class, begin reunification, family therapy prior to the children, give petitioner at least 7 days advance notice before the first appointment, opportunity to provide collateral information to the evaluator, and then start and complete treatment as provided by an evaluation. And the court, Ms. Litos may not petition the court for visitation with children until such a time as she has completed the above recommendations. Okay.
So
All right.
basically what I did was took the old parenting plan in and added abandonment. All the other findings were done at trial. The abandonment's the new one. And then basically I didn't want to move to Pennsylvania and then be held in contempt because I couldn't make a visitation if she set up supervised visitation. On top of it, I don't think it's good for kids to not see a parent for 2 years, go through that mourning phase, and then have them have the opportunity to randomly show up and disrupt our life after such a long period of absence. That's not healthy. That's,
Okay.
you know.
All right, thank you. Okay, so let me just systematically work through this. So with regard to the motion for adequate cause, there's been no formal response to that. Ms. Litos was given notice of today's hearing. She was present. There was an order setting a readiness hearing for April 4th, which she was present at that time. That's where the court set the, pardon me, she was not here on the 4th. I misspoke. Yeah, so she was not here on that date. Yeah, so so then I guess that order that sets the trial date is kind of a key piece there. There's a notice of a trial date that's dated March 2nd, 2023. That's where it lists a pretrial that would be heard on March 16th, a readiness hearing on April 4th, and then the trial is noted a week of April 10th as being that time frame. And that was sent to Ms. Litos at 606 Columbia Street, Kelso, Washington, 98626. Then that notice was returned to sender, unable to forward. And it says a copy has been forwarded to Ms. Litos at Post Office Box 5484, Tacoma, Washington, 98415. Ms. Hiltz indicates that that post office box is still a good post office box as manifested by a current pay stub that lists that same post office box for Ms. Litos. Ms. Hiltz, do you have a copy of that pay stub in your possession or in any of the pleadings?
They're not in the pleadings because I just received them, and I actually was, because we're done here, I was going to come file them because it's relevant to the contempt for not paying child support that we're going to hear on Thursday.
Okay.
So the court will have them shortly.
Do you have them now?
I do have them now.
If you could find that and then share it with me. Either share it or just hold it up to the screen so I can look at it carefully. See, I'm dealing with this. I have to do it to the large screen, and then when I speak, it pulls up my face, which I don't want to see, but I want to see the document you're holding. So when you're holding up, I just need some noise coming from your end of things.
No problem. I can keep talking so that the camera focuses on me, and I can move forward to bring in the address here.
Okay, and can you read the address?
Washington.
And what's the date of the pay stub?
Oh, this one that you were looking at is a pay date of 12/23/22. But the most recent one I have is from March 3rd of this year. I just grabbed one of the sheets. She sent me 4 or 5.
And that pay stub from March 3rd, 2023, does it have the same post office box number?
It does. The same PO box.
And that, as far as your knowledge, that particular post office box, or pardon me, that particular employer, that job that she has, is that a job that she's had for how long roughly?
According to the interrogatories, The date you first, oh, that's first present. copy. I thought it was somewhere in 2021.
Okay, okay, so she's.
Sorry, I didn't really go over her. Oh, October of 2021.
Okay, so about a year and a half.
Yeah, I mean, I did, you know, I figured I'd prep all the financial information before Thursday.
Okay, all right, so that notice of the trial date, it shows to the Kelso address, it was returned to sender, unable to forward, and it also indicated that it was sent to the post office box at 50. That notice of trial date indicates that on April 4th, there'd be a trial readiness hearing, and then the trial would be the week of April 10th. So then we look at the dates in which parties were present. We have a trial or a hearing date on March 23rd. This is a show cause contempt hearing related to, I believe, child support issues and failure to use the Talking Parents app. And at that time, the court did not rule on the contempt. It says Mr. Lawrence questioned the court regarding the week of April 10th, that's the trial, and not sure of the hearing on the 13th. So that's alluding to what you indicated before, Ms. Hiltz, is that there was some discussion related to that in that hearing. And then the court indicated the trial may address the contempt. And then discussion regarding the next review date, the court set that to April 13th. At that time, it looks like. So and at that time, Ms. Litos was present. Then there was a motion filed regarding failure to comply with discovery on April 4th, of which Ms. Litos was notified via the trial scheduling order. The trial set the trial date for today, April 10th at 9 a.m. And she was not present on that date. So I think there's sufficient information to show that Ms. Litos was served with the trial scheduling order, which set April 4th as a date of a readiness hearing. She was present. She received that document by the indication that there's a post office box that's receiving a current pay stub, and pay stubs are generally accompanied by a check. So there's some good indication that she's receiving that information. The motion for adequate cause has not yet been addressed. There's been no formal response to that. So I'll make a finding of adequate cause based on the representations and the pleadings of Ms. Hiltz that there's been no visitation with the children and that there's chemical dependency concerns. So I'll make that finding that there is adequate cause. The motion or the petition to modify the parenting plan is tied to that adequate cause finding. So since there is adequate cause and that there has been a petition filed for a change of the parenting plan, I'll grant the petition to modify the parenting plan as proposed and submitted in the pleading from December 13. So that proposed parenting plan will be the one that the court adopts. The court also makes note of the notice of the intended relocation. The court knows that there's been no formal response to that. And so I'll grant that motion to relocate with the children. There is a presumption, obviously, with Ms. Hiltz being the primary custodial parent that she's permitted to move, and without any opposition, that's clear that that relocation should occur. The notice of each of those proposed parenting plans, the motion for adequate cause, the notice for relocations, the summons, the petition was captured through motions to serve by mail, and there was an order allowing service by mail, and that was filed on January 20th that allowed for a service at the post office box 98415. Again, that's the same post office box where Ms. Litos is receiving her pay stubs as recently as March 3rd and also prior on December 23rd, 2022. Those are the pay stub dates. And that the trial scheduling order was sent to that same post office box. It was not returned, no indication that it was returned within the file. And so I think based on that, I'll make a fine, I'll grant the requested relief based on a default finding. And so Ms. Hills, so there's some proposed orders that I would ask that you file, and if you, I don't know, you may have already filed them. Have you filed proposed orders?
I'm not sure. You want to
Okay.
propose parenting plan or propose? I printed out things that I don't know that the clerk took because we weren't there yet. Is that the final order on findings and petition to change a parenting plan or custody order?
That would be one of them, yes. Yeah. We would need, I would need a some type of order that grants the petition to modify the parenting plan. So I'd need that. And then I would need a final parenting plan that mirrors your proposed parenting plan.
Okay,
I would also need an order granting the adequate cause motion.
okay,
And I think that's it. I think that's it.
okay.
And having said that, as you're probably aware, defaults are not favored in the law. The law wants to resolve issues on their merits. So there may be, you know, I'll sign off on those orders that you present. There may be a motion to reverse the default based on concerns related to this April 14th date or April 13th date that was set in open court on March 23rd. So just be aware that that's a possibility.
Out of curiosity, how long does a party normally have to file a motion to reverse a default? Because this is how our last trial ended up too. It was a 3-day trial and then she didn't show, which she didn't. I'm more curious, I guess, is.
Yeah,
how
I'm
long
not
do I-
aware of a specific time frame that's outlined in either statute or case law. I think it tends to be case specific.
That's fine. I was just curious if there was a time when I could relax and go, okay, this is done, you know?
Right.
So, all right, thank you.
Yeah, when do you think that you'd be able to supply the court with those orders that we talked about?
I'm probably gonna watch the last few minutes of this YouTube over and over again until I figure out exactly what you asked for and make it happen today. So.
Okay. All right, great. Okay, so we'll look forward to those. Once I receive those, I'll sign them and then I'll hand them back to the clerk and they'll be filed and they'll be available via Odyssey. At this point, Ms. Hiltz, do you have any questions or anything you want to review just before we end the call?
No, I don't think so.
Okay.
I mean,
All right, very good. Well, look forward. Oh, one question I wanted to ask you is that you supplied some exhibits to the court for today's trial. Return them.
if they want to give me the binder back when I show up, I'll take it. That's
The
great.
binder?
You know, if not, the rest of it can be shredded. So,
Okay.
or they can give me the whole thing, whatever.
Okay, we'll give you the binder back and the other ones that were supplied, which is just a mirror copy of those. We'll have the clerk destroy those, but we'll make sure you get the binder back. Okay.
All right.
All right, very good. All right, so with that, I think we'll go ahead and end the call today. Thank you for being present, Ms. Hiltz, and good luck with everything.
Thank you.